Hello, everybody. Thank you so much for joining us for the CLE program. We are really excited to be here. I'm Ali Muhammad. I'm the CEO here at JuristAI. I have with us one of our prestigious board members who will tell you a little bit about herself, Agnes. We're going to be talking about a really important topic today, hallucinations. I am a software engineer and solutions architect by profession, but I also spent some time as a paralegal when I was younger. So that was my introduction to the law. Agnes, if you could tell us a little bit about yourself before we get started.
Sure. My name is Agnes Malatinsky. I'm an attorney. I've worked with a number of startups, including co-founding my own legal tech startup, and I'm also ex Thomson Reuters.
Awesome. Thank you so much for that. So today we're going to be talking about false AI hallucinations, fake citations, and legal risk. And we're going to be focusing specifically on what every lawyer needs to know about verifying content that comes out of artificial intelligence and whether or not artificial intelligence is reliable for legal use cases. So, what is an AI hallucination? At this point, generative AI has kind of taken the world by storm and it's causing quite a sea shift in the law and in legal practice. So, what's a hallucination? Hallucination is when generative AI creates a false fact. So, the way that large language models work is they try to guess what's the next best word in a sequence, what's the next best sentence in a paragraph, and what is the next best paragraph in a series of paragraphs. So, since it's doing these calculations to try to figure out what the next best token is or what the next best word is, it doesn't actually have any humility. AI does not know how to say, oh, I don't know, because it's not pulling from facts, it's not pulling from memories, it's not like the talented attorneys part of this CLE program where it's pulling from a repository of experience and knowledge. What it's doing is almost like a math problem. And to these AI models, these citations look a lot like formulas or equations. So it's essentially rolling the dice to try to figure out what the next best letter or word is when it's trying to produce a legal site. And so that's really problematic because legal sites have to resolve back to an exact factual basis. Why do hallucinations occur? AI models generate language statistically, not logically. So they are just trying to predict what sounds right, not what's true. They're not automatically performing some kind of research when they're giving you a site. And these base models actually can't even check real cases against pin sites, let alone check whether quotes are exact or even real, and let alone check relevancy for the arguments that you're making. So without some kind of external verification process, whether that's a human going in and copy pasting something that AI has given you into LexisNexis or Westlaw, or some kind of software validation layer, even advanced LLMs, large language models, can sound extremely precise, be very overconfident while being 100% completely wrong. And if you go to ChatGPT or you go to Gemini or whatever your favorite AI model is, and you play around with it, you try to get it to draft briefs or contracts, eventually it will start making stuff up if you're being diligent and looking at the outputs carefully. So, when are users most at the risk of hallucinations occurring? AI models produce their outputs based on something called context. So, context refers to the amount of strings, the amount of text that is already submitted by the user within a particular chat or within a particular thread. So the longer that that context window gets, the more that you use a particular AI for a particular conversation or thread or series of conversations, the easier it is for the AI to get confused because it's less dependent on its base training and base data and trying to overcorrect for what you've already submitted. Additionally, when you have a niche use case or you're working in a practice area that maybe the model wasn't trained to be attuned to specifically, it gets pushed to the limit. So the context gets burdened, and the AI model is trying its best to perform these calculations to figure out what to say next, but now it's really under strain. And that applies with base generative AI models, ones that are not designed for law, but it also applies to chatbots that are designed for legal use cases, even ones from big providers. Additionally, if a user is not very familiar with the nuances of prompt engineering or how to construct your messages when you send them to a model in a very particular way to elicit very particular responses, it's likely that you won't know some of the pitfalls that lead to AI or precipitate AI hallucinations. So, what kind of AI actually produces hallucinations? The most important thing is how the overall solution is architected and not necessarily how the model is trained. So, whether we're talking about base AI models or legal models, sometimes the training doesn't necessarily improve the output results. Both can hallucinate, whether it's a general AI model like ChatGPT or Gemini, or whether it's a legal specific model. And some early research sometimes indicates that when models are trained specifically for legal use case, they may actually perform worse. We have a research study here from Stanford that you guys can take a look at to that end. Now, there is something called RAG, or retrieval augmented generation, and this relies on the generative model realizing or making these external calls and saying, look, I need to go do some research to try and pull from an actual data set. And that does lower the risk, but it doesn't totally ameliorate the likelihood that it will just make something up. But at the cutting edge of legal tech, there are hybrid solutions. So hybrid solutions use generative AI, they use LLMs, but they also have some kind of built-in software validation layer, which is trying to check whether or not the sites are real. The most primitive kind of this is just taking a site and the software will ask the chatbot, hey, did you hallucinate this? That's extremely primitive. And if it hallucinated, it may just double down as these models are trained to be very overconfident. But there are some really sophisticated solutions that we'll take a look at later that can highly reduce the likelihood that you'll ever see a false site out of the software that you're using. And it's important to keep in mind that not every AI solution is the same. Some solutions use AI for a small fraction of what they're doing, and some other offerings are entirely AI and don't really offer much protection against this problem of hallucinations. So what we do here at JuristAI to try and preempt and remove hallucinations from our work outputs is a multi-layered approach where we acknowledge what generative AI is great at, and we also acknowledge what we don't trust it with. And the future of legal tech really will depend on having these kinds of robust hybrid solutions that are not just AI models trained or slanted towards the law, but are built specifically for the way that legal workflows work. So, one of the most important things is having controlled input channels. That means that AI should be getting fed the right sources of information and the user should only be receiving certain kinds of information that come from validated sources. Statutes, rules, case law sites, local code, none of that should ever come from generative AI. It should come from validated legal research databases. Whenever something is quoted, whenever you receive a source from an output, there should always be an external link that you can click on that takes you right back to that opinion or that local rule so that you can read it and make sure not only that it's real, but that it's been quoted correctly and that it's actually relevant to what it is that you're trying to accomplish. Context isolation is really important. We talked about context burdening, but carefully controlling and manipulating as many contexts as is necessary so that you can get the exact AI outputs for what you need alongside validated research is essential to producing work products that are accurate, that don't have that kind of shift, and that don't start hallucinating. And then finally, we have in-house hallucination detection that scans the outputs of AI for site patterns that should either be removed or validated.
All right, so let's name the 4 failure modes we see most often in AI-assisted legal writing and what they look like in the real world. Every AI miss that you encounter falls into one of these legal risk types, from fabrication to just irrelevance. I'll start with the mildest flavor of these, irrelevant citations. This is where the cite is technically real, but it's inappropriate to the issue that you're briefing. For example, you're moving for a preliminary injunction and the AI drops Twombly to talk about pleading standards. So the citation exists, but it sort of quietly undercuts your argument because it doesn't address the injunction factors. So that's an irrelevant cite. Second are fake quotes. This is where the case and the reporter cite are real, but the exact quoted language never appears in the opinion. An example of this is, a memo quotes a bright line rule that sounds perfect. And then when you go to open the case, the court never used that phrasing. This is more of a credibility killer because it reads as fabrication, not as a good faith mistake. Next are fake pin cites. This is where the case is real, but the pinpoint page or parallel cite is wrong. For example, the AI cites a controlling passage on page 412. Opposing counsel opens the opinion, and page 412 discusses jurisdiction, not your doctrine. So now you've misdirected the court to the wrong part of the case. And then finally, non-existent authorities. This is the worst. Case, name, and jurisdiction that have never produced such an opinion. It's pure invention. Obviously, the fastest path to sanctions, and unfortunately, something we've been seeing a lot of in the news lately. So think of these as a continuum. Again, at the milder end, we have irrelevance, waste space, weakens your logic. In the middle, fake quotes, fake pin cites, distort meaning, and at the extreme, non-existent cases are outright false. Your process and your tooling must be designed to prevent all 4 of these from breaching a filing. Next slide, please. So when can AI be trusted? Reliability in legal AI is not a vibe. It's engineered epistemic control. And there's really 4 guardrails that turn any clever text generator into more of a professional grade system. What we really want is domain grounding with human verification baked in. The system is grounded in legal sources, and a lawyer remains the final validator. So, for example, statutes, rules, and cases come from your approved databases, and at the end, a human signs off before filing. The first one I want to talk about here is context isolation. This is where every matter, user context, and task live in their own reasoning space, so facts don't leak. For example, if you have a Acme v. Baker case, the facts never bleed into Acme v. City, even if the parties overlap. This avoids cross-pollination errors. The second are, where you retrieve truth before you generate. The tool pulls the primary sources first, then binds each sentence and each citation to something verifiable. It won't draft the standard unless it has the controlling case open in memory and with a link. Third, deterministic verification. We don't hope that the model was careful. We check it deterministically. For example, the system compares quoted strings to the retrieved PDF text and validates reporter and pin site patterns before the output can be finalized. And then finally, human auditability. Every assertion is traceable. It has clickable links, verifiable logs, and reasoning snapshots. In an ideal case, a partner can replay the chain, what was retrieved, what was cited, and why that sentence exists. That's how you preserve candor and competence. When these guardrails are present, you can safely assign routine drafting to the machine and sleep at night. Without them, you're always rolling the dice. So is this problem unfixable? Again, something that there's been a lot of headlines about. The short answer is no, with the appropriate architecture and workflow in place. At the raw model level, as Ollie was saying, all the big large language models, hallucinations are inevitable. LLMs are probabilistic predictors. They will likely never hit a zero error standards. That's sort of a property of the math behind it. But legal tech doesn't have to inherit that risk. The fix is architectural, to where we pair deterministic retrieval with explicit hallucination detection and keep an attorney in the loop as the validator. So now the model can guess internally, but the system stops guesses from entering the brief. So some concrete examples of the fix in action are like a name check gate, where the system blocks any case name that can't be resolved to a real reporter entry. Fabricated authorities are never rendered. Or a quote match gate, where any quoted string must appear in the retrieved opinion. If not, the tool replaces it with a paraphrase or prompts you to pick a verified passage. And then task segregation. So research, drafting, and citation binding run as separate steps with their own contexts. If a user accidentally pastes in facts from another case or another matter, isolation prevents contamination. So bottom line, are hallucinations unfixable? At the model level, very likely yes, they're inherent. At the system level, no. We can make them rare, detectable exceptions that never reach the court. But of course, building these fixes is very complex, which is why many tools don't include them. Next slide. Is it worth using AI given this risk? And I think Ollie and I spend most of our time talking to lawyers about this. It really depends on which AI you use and how you deploy it. A base chatbot, even a legal one, doesn't guarantee verified sources. Asking an LLM to check in its own work is never going to be reliable because they're sycophantic. They want to confirm their own results. They're going to make up new stuff when they're checking the work. Whereas hybrid systems that retrieve and verify sources before writing materially increase the competence. So the pragmatic sort of calculus is, professional competence now includes technological competence. If your tools can anchor every proposition to a primary source link, you can reduce drafting time while raising accuracy. And then there's also the consideration of work allocation shifts. Routine, pattern-based filings like standard motions, discovery letters, fee petitions, trend toward automation with lawyer supervision, whereas novel legal reasoning remains and will likely always remain human-led, with AI accelerating research and outline drafting. Two contrasting examples here are, your use of a base chatbot scenario or like a non-robust tool scenario. Two contrasting examples here. One, we're using, a base chatbot scenario or a non-robust legal tool scenario. You prompt it for a Rule 12b6 motion. It returns plausible text with 5 cites. Now you have to go in and manually open each case, verify every quote, fix 2 pin cites. Your time saved is negligible, if any, and your risk is elevated. A complaint we hear all the time is in this type of workflow, it's actually just not worth it. It takes much longer than it would have to do it manually. So, in something like this, it might not be worth it to adopt a new tool into your firm. Whereas with a hybrid scenario, the tool refuses to draft until it has retrieved controlling cases, every quote is string matched, every site is linkable, and a verification log is produced for your file. Here you spend your time tailoring facts and strategy, not cleaning up citations. And this is where the cost benefit analysis really tips. So bottom line, use it AI, but make sure you have the right architecture. Make sure your vendors have the right architecture. That's how you get speed and safety. And that's where the profession is heading.
Hello, I'm Mark Underwood, Chief Legal Officer for JuristAI. I'm taking over the presentation, starting with the slide consequences of submitting AI hallucinations in court. Let's talk about competence and supervision. The ABA Model Rule 1.1, Comment 8, makes technology competence a present tense duty. We must understand that AI helps where it fails and what safeguards are necessary. The duty propagates across all firm actions when using AI. Under Rule 5.1 and 5.3, partners and managers must put reasonable measures in place so lawyers and non-lawyers, including vendors and AI systems, are appropriately supervised. In practice, a written AI policy, approved tools and versions, roles-based access, short training, and light but real audits to confirm people follow the rules are extremely important when instigating and in using AI tools in your practice. Candor and certifications are another part of the responsibility for you in your practice areas. Rule 3.3 requires candor to the tribunal. What this means is you pair that with FRCP 11B and Rule 26G that notes your signature certifies that you are making factual legal contentions, that they're warranted after reasonable inquiry. A model's confident paragraph is not reasonable inquiry. Reasonableness is verified authority and verified record citations. We've been working on the hallucination perspective here, and that's what we're presenting today. But that doesn't supervene any human interaction, which I contend is necessary in all forms of AI intervention in your practice. A model's confident paragraph is not a reasonable inquiry, as I mentioned just briefly ago. Reasonableness, again, is verified by authority and record citations. And what this means is if you don't do that, you have to be disciplined, or will be disciplined rather, by the courts, as we've seen in previous slides. But also, you have to use discipline to verify and then file. Bind propositions of law to primary sources within your PIN sites. Bind facts to the record or authenticated ECF entries in the federal PACER record. Keep short verification appendices showing that you have checked this so that you have an audit trail moving forward. Confidentiality and communications. Rule 1.6 requires us to preserve confidentiality. If a tool logs, prompts, retains, uploads, allows human access, or trains on your matters, contractually disable those behaviors or keep confidential content out of your AI interactions. Under Rule 1.4, when AI materially affects confidentiality, cost, or timing, explain it and the document in informed consent. This is a must. Elevate your human interaction and intervention by using drafts offline for criminal exposure, minors, PHI, immigration, or sealed materials. If you run afoul of this, the sanctions will be much higher than those we have previously discussed in our slideshow. As a CLE, I want to make sure that you understand that you have an obligation both to your client and to the ethics rules of your particular state, and in the case of federal, with the federal courts, which are very, very clear on how they're going to manage AI in the future. At least in the short-term future, I expect that these rules will evolve over time. Let's also talk now about UPL and local orders. Model Rule 5.5 bars unauthorized practice of law, of course, and AI is not your junior associate. It's a drafting assistant under a lawyer's review. Understand all the hyperbole around sales, including here at JuristAI, are required by law for you to understand that we are not lawyers. This is not a law practice associate, though we may use that sort of market speak. Some judges now require disclosure of AI use or certifications that citations have been verified. That's what this tool purports to do for you. That said, every district that I currently have access to through PACER requires any litigant or representative of that litigant, whether pro se or you as a lawyer, requires an affidavit saying that if you used AI, human intervention was involved. Know your judge's standing orders whenever you're practicing in a particular district and comply by letter or affidavit with the court. The architecture of any LLM is not alchemy. Base LLMs are probabilistic. Left alone, they'll hallucinate. Legal reliability is an engineering problem that we have worked on and believe we have the best solution for. Retrieval before generation from verified sources, official reporters, authenticated PACER, ECF, and client records. In JuristAI's platform, we are directly connected with PACER. The record is there. PACER is slow. It's been hacked. You have a responsibility to, once again, regardless of the tool set, authenticate and verify. Deterministic verification programmatically confirm case existence, quotations, and pin sites before any human signs any pleadings. Human auditability, hyperlinks to the primary sources which we include in JuristAI, plus a short verification appendix and an internal audit log are a necessity, I believe, in your practice roadmap. Put it into your playbooks. This will ensure that as you're using AI to inherently help your practice value, if you have the audit logs and you can prove this, then you're being transparent to your practice, to your clients, and to the courts. Here's an example. An associate pastes sealed excerpts into a public chat bot and that trains on inputs, and that's every one of the public chat bots. That is a huge 1.6 problem. It may also jeopardize work product and privilege, very likely so. There's a process fix. Approved tools only, zero retention mode, verification before anything leaves the building, meaning electronically as well as in the old days when I started practicing, any documents that you were sending out. Then you also must supervisory fix, meaning train plus periodic audits. That should be part of your roadmap and playbook as well. Here are some checklists that you can use starting tomorrow. Name approved tools and versions. Require verification appendices for any AI-assisted court filing. Disable training and broad logging in vendor terms. Route sensitive matters to private instances or offline drafting. Give partners a one-page audit sheet. If it isn't verified, it isn't filed. The takeaway is AI doesn't change our duties. It heightens our duty to design safe processes. Engineer compliance first, then scale speed. Moving on to our next slide, AI hallucinates. We have a case sites database. We're connected, as I had mentioned before, to Pacer that doesn't abrogate your duty to your clients and to the courts. Let's talk about privilege, cloud AI, and your new duty to explain. There's a practical duty to explain to clients when and if you're using AI, as well as to the courts, and how you protect information in your practice while using these tools. That hasn't really changed much, except in this particular case, as we discussed in the previous slide, your duty extends to the AI platform that you're working on. Privilege and work product are part of the necessity of what you need to manage here. Privilege can be compromised by exposing matter content to third parties without adequate protection. Preserve it by design. Choose providers that prohibit training on your data. Restrict human access with immutable logs. Enforce encryption in transit and at rest. Honor deletion schedules. When I'm talking about deletion schedules, I'm talking about data retention policies that your firm, you as a solo practitioner, and the terms of service that apply in the case of any AI tools that you're using. Segregate matters by tenant, project. Hopefully that makes sense to you all. You should do that as part of your state obligations and the ABA rules, as well as part of your duty to preserve. Store verification artifacts separately, label them as work product. Vendor controls that mirror Rule 1.6. Your baseline DPA should include no training on inputs or outputs, encryption requirements, role-based access and audit trails, retention and deletion SLAs, timely breach notice, controls on subcontractors, and narrow assistance clauses for discovery that keeps you in control. If the provider can't agree, do not use the tool for confidential matters. And we briefly touched on that in the previous slide where you can delete your information, run the hypothesis against the AI model, ensure that the pin sites are there, then add back with your human intervention playbook the matter for your client, and then you'll be very likely much more compliant in your approach. Let's talk briefly about client-informed consent. This is a Rule 1.4 matter. If AI materially changes the confidentiality profile, the timing, or cost, your obligation to the client is to tell them that what the tool does, how you protect data, and what they gain. Keep that explanation in your file. If you're using things online, you can, in a limited sense, use some click wrap or click browse at the very least in your disclaimer sets, as well as access to client data when a client comes into your portal. There are sensitivity tiers as well. For criminal exposure, minors, PHI, immigration, or sealed cases, you must elevate your controls. Private instances only, no external retention, consider offline drafting for the most sensitive of the passages that are in any of your pleading. Document your tiered decisions in this. Again, it's incumbent on you to have a playbook across the board for these. Let's move on to your discovery posture. Expect requests for prompts, traces, or telemetry from other counsel or opposing counsel. This is going to be more and more part of a playbook that your opponents are going to use as lawyers become attuned to how LLMs work and their inherent flaws, and they're going to test your playbook, and that's why talking to you about it today will benefit you both short and long term. Keep verification appendices tying each quotation and each citation to its source, and each as they are affecting the record for your pleadings. At Rule 26 conferences, lean on proportionality under 26B1. The appendix should suffice. Raw prompts and internal logs are not discoverable absent specific good cause. And understand, specific good cause can be determined by the courts, and you don't want to get there, so build this out. If a court orders AI-related discovery, seek a protective order, tightly scoping what, who, and how, and exclude the model internals and vendor trade secrets. There's a multiplicity of danger here. Be aware, reach out if you have questions on this one, because if you haven't seen any of my particular open source model information in copyright and other governance, this is something we should talk about, and we can talk about it in another CLE, or we can talk about it offline. Feel free to contact me directly. Here's an illustration. Opposing counsel claims your motion cites a case that doesn't exist. You produce the verification appendix, linking the citation to the official reporter, typically something on Pacer, or in your, if you're using any court listener, whatever you're using, whatever your verification process and how you're posting that back to a particular ECF entry, and require a short declaration explaining your verification process. You do not produce raw prompts. You do not produce vendor telemetry. You do not waive privilege. Here's the takeaway, people. Privilege is protected in procurement and architecture, not in the middle of a discovery fight. Lock vendor terms and processes before you draft any discovery documents or before you draft any pleadings. And that's my largest caveat to you and a big takeaway for you all today. Moving on to the next slide. This slide is talking about how automation is to accelerate processes, not judgment. And you probably caught on to my approach to how you and I do have roadmaps for my practice, and I am practicing as counsel as well. We have several use cases in play where I am acting in the Western District of Michigan in the federal practice area for that district court. I also act pro hoc vice as a use case to ensure compliance for pro se in an unbundled way as part of how we are approaching AI in practice. So if you're going to move to a playbook, you move from policy to practice, use verification logs and accountability. On this slide, it's sort of a how slide. We translate policy into day-to-day practice so your filings are fast, accurate, and defensible. I urge you, adopt a Gen AI policy that people actually use in your practice. List approved tools and versions, allowed and banned use cases, routing rules for sensitive matters, role-based access, logging, and incident response. You have to approach this very much like any enterprise does. And those of you who have practiced with enterprise companies understand the playbooks that must be in place there. We need to apply those to your law practices, your business as well, but compliance with the ABA and your state's rules are absolutely necessary. Forbid public models for client work unless the controls truly match your policies, as we just discussed. Require short training and periodic attestations from all of your staff. Anyone who touches client files helps draft pleadings, whether paralegal or assistants. Here are 4 controls that I would recommend that do 90% of the work. Bounded sources, draft from authenticated corpora. Official reporters, pacers, state e-filing downloads, client documents, your firm knowledge base. Keep the models inside those boundaries. Cite binding, meaning bind legal assertions to primary authorities with pin cites. Bind facts to record evidence. No pin cite, no filing. Always, always human intervention, human review. Assign a verifying attorney whose job it is to check that binding is in place and to catch any mismatches, not redraft from scratch. This is very much like doing a red line in your contract practice. You do it with your pleadings, with human intervention and oversight. It must be part of your playbook. You sign verifications. Any internal paper record the date, the matter, the tool and version, the bounded sources, and the scope of human review. That's your Rule 1126G backbone. Hallucination checker and logs. Run an automated check that validates your case existence, quotations, and pin sites against trusted sources, flags, flags, conflicts, and export two things: a court-ready verification appendix that can travel with the filing or be held in reserve. I typically hold them in reserve unless unless required by the court or required under some discovery rule as bound by the court as well. An internal audit log with timestamps and tool versions. We've talked about this, and you're gonna feel like you're being beaten over the head by it, but that's not what I'm trying to do. I'm trying to impart to you the very necessity of and use case for AI in your practice. Once you have those in place, also consider that the appendix is client and court facing. The internal log is work product. Work product, going back to the discovery thought process, is not something that's typically discoverable. It would have to be ordered by the court. That's why having the audit trail is so very, very important. Training audits, incidents, and other things that you should consider. Train your users with a 30-minute module and have at least a 2-page quick reference guide. Sample 10% of your filings for spot audits. This is something that you can put into your governance for AI practice. The playbook that I keep discussing. Keep an AI use log per matter. If an error slips through, fix it fast, notify, correct, and amend. You have to amend the paper that's filed, meaning if it's an ECF, you have to refile it with an amendment. Not necessarily a notice to the court. You may actually have to move to amend by motion. Where was I now? Hang on. Courts reward candor and process sanctions. Excuse me. Apologies. I want to spin that back because this is important. Courts reward candor and process. Sanctions tend to follow denial and delay. In all the cases that I believe Ali has talked to you about, and you've probably seen reported on both LinkedIn and in major newspapers, there were denials or they didn't follow AI rules that the courts had in place. What this tool, Instant Tool, our hallucination detection platform does, what it's going to look like for you and how you add it into your practice. You can add a one-page verification checklist to your templates, require the verification appendix for any AI-assisted motion, configure your vendor to 0 retention and no training, give partners a simple audit sheet for checkboxes for the 4 controls that we just discussed. Let me recapitulate that for you. I need to start that over. What this looks like tomorrow morning. Add a one-page verification checklist to your templates. Require the verification appendix for any AI-assisted motion. Configure your vendor to 0 retention and no trainings. Give partners a simple audit sheet, 4 checkboxes for 4 controls. Here's your takeaway from this particular slide and from this discussion that I'm giving and asking of you. Speed comes from engineered guardrails. Verification is a habit, not a heroic event. Make it routine, and you'll avoid the sanction orders that make headlines. Let's move on to my last discussion topic for you all. What if you're not using a hybrid tool? We talked briefly in the past slides about how you build out a playbook. Let's talk about building specifically a manual verification workflow. Framing. This is a court-safe fallback when you're not using a hybrid verification aware system. It's simple. Bound the sources, anchors every citation while drafting, then verify before filing. Keep a short review log. Source of truth retrieval. Gather verified sources before going to AI. The model should only see what you already trust. Pull controlling authority from official reporters or authenticated PACER, ECF, state filing downloads. Download the full opinions you plan to cite. Don't rely on snippets. Things taken out of context can be misjudged as AI, even in normal pleadings now. Normal pleadings meaning those that you've completely drafted without the assistance of any tools online, including LLMs. Assemble the record, exhibits, declarations, and transcripts. Label them with Bates, ECF IDs, pretend, in fact, that everything you're doing is old school, where you actually put taggings in for the benefit of the court, for instance. Create a matter truth binder. This is a folder or a DMS workspace holding the opinions and the records you're going to allow for the drafting. For sensitive categories, criminal exposure, minors, PHI, immigration, or sealed materials, as I've mentioned before, elevate your controls. Use a private instance or offline drafting for those excerpts. Here's a practice cue. If it isn't in the binder, it's not in the draft. Require citation anchoring while drafting. Limit the model to your research corpus. Ensure nothing gets added that you didn't approve. Remember, in your overarching playbook, someone else in your firm is going to read this, or you're going to have a secondary review yourself if you're solo. No proposition of the law without a primary source and a pin site. Make sure that that is key to how you move forward using this solution. Set a rule. No pin site, no paragraph. Again, no proposition of law without a primary source and a pin site. No pin site, no paragraph. Facts must be bound to the record. This means ECF or Bates, an exhibit ID, text, footnotes. Use your drafting of pleadings. Use the footnotes well in how you manage those pleadings. This will make sure that when you are using any tools in AI, you're getting an output that you have helped craft and that you understand is associated with your logs. Draft inside a template that forces anchors. Each paragraph has a field for authority, pin, and record sites. Using AI, point out only at the truth binder Prohibit web and open corpus retrieval, meaning don't use open source models that you aren't paying for and you're not subscribed to. Use those at your peril. This is a key fact. Insert quotations from the source PDF or from your source Word document, not from memory or the model. Then add page pins immediately. Here's a practice cue again, like I discussed in a previous slide. Author the anchors first, prose second. The model can help with prose, but not invent the anchors. And again, this hallucination tool is of benefit to you because it's directly connected to Pacer. You are responsible, however, for your ECF and pin sites. Do an existence check. Confirm every case actually exists and matches your caption and citation. Do a quote check. Confirm quoted text appears verbatim on your cited page. Fix punctuation, ellipses, etc. Add or clean up only if it's appropriate. Do a pin site check. Each proposition point to the correct page and paragraph. Add pin sites where missing. This is key when you're looking back at the record, especially in Pacer, and you look at the ECF record. Recognize that those pin sites are key to referral back when you're filing again or later and correlating it to the record as it exists. Relevance check. Use real cases. Wrong issue. That's a problem. That was in California. One of the earlier references was to a very large sanction against an attorney who didn't follow the association of the actual to the case theory that was crafted in the pleading. That's a misquote that almost anyone can do, but is being particularly associated with AI. So do the the relevance check. Do the record check. Each factual assertion has a record site that resolves to the exhibits in ECF that I was just talking about. Blue Book and local rule pass. Check your headings, short forms, spacing consistencies, all the local rules that apply, because in my survey of use of open source AI, there's no quality way to format things properly. So you have to go back and manage most of that yourself, especially with your headers and any of your quotations that you have in your document. And that's why Blue Book and local rules you have to take very careful action against. There's a great deal of difference between the Western District of Michigan, the Eastern District of New York, the Western District of Texas. Just be aware. Export to artifacts, a short verification appendix. That means a table with proposition, authority, PIN, record site, and link to the ECF ID. Secondarily, do an internal audit log, date verifier tool, a version if any, sources checked, exceptions noted and resolved. For your review log, keep it simple, make it routine. Who verified, which citation, when and against what source. The fields that you should include are matter, document, paragraph ID, authority, PIN, record site, verifier, date and time, notes. Label an attorney work product. Again, we talked about that briefly when I talked about discovery. Stored alongside the draft that you have in your DMS. Let's talk about retention. Align your retention to your litigation hold. Purge according to policy after the matter closes. Why it matters. If challenged, you lead with the verification appendix you keep in the log and in reserve unless the court orders it. Tomorrow, you're going to implement this. This is a 15-minute huddle you have with your team. Make this operational as quickly as possible. Add a one-page verification checklist to your motion templates. Create a standard truth binder and folder structure for your DMS. Switch any AI tool to zero retention and no training, or keep AI out of this matter. Assign a verifying attorney, or if you're solo, make sure that you go back and act as verifying attorney on the title page. You own the anchors and they own the final pass, or vice versa. Here are your metrics for the month. 0 fabricated citations, less than 1% pin site errors, 100% appendix compliance. If you do this, you're going to be fully compliant for the future. Here's my closing. Speed, which almost every AI model tells you is going to be one of the key benefits, has to come from guardrails, not from shortcuts. Follow these 3 steps, and this review log, you'll be able to file faster and safer without needing a hybrid tool. That's what I have for my wrap up. I'm going to turn it back over to Ali and the team.
And then here are some small blurbs about your wonderful presenters today. I've told you about myself. We have with us Agnes, and we have with us Mark, our Chief Legal Officer. And that's it for the presentation side. We're going to get into an actual demo of one of our products, but you guys have a 15-minute break. In the meantime, go grab some coffee, possibly open up juristai.org, take a look around, and I will see you after the break. So how does JuristAI tackle this problem of hallucinations? JuristAI's products are end-to-end case management tools that utilize AI where it makes sense, but that relies on traditional legal reasoning to ensure accuracy and high quality work products. So one of the ways that we approach the issue of hallucinations is by ensuring that our products are practice area and jurisdictionally specific. We had mentioned that the niche aspect, the nuance, and the specificity of a practice area can start to throw AI off. So unless you build in the guardrails with experienced attorneys that have operated in that particular area of law, and you feed that kind of expertise into the AI model and also post-process the outputs to ensure that the outputs are aligned with actual real world legal expertise, then you cannot guarantee any degree of accuracy. So we take an approach of first determining the rules, the statutes, the controlling opinions, and the life cycle of a particular practice area. And then we stretch it out across various jurisdictions to make it jurisdictionally specific as well. We are currently live in federal civil litigation and will be releasing state civil litigation for Q1 of next year. We're also live in federal criminal defense. We're moving into bankruptcy law early next year. Additionally, just to make the platform easy to use for users, we offer the entire suite over email, and we'll take a look at that. But essentially, that means you don't have to learn a new interface. We set up an email address for you, and you interact with that email address the way that you would an associate. It's also highly proactive and autonomous. So it will go out and work on your case, the email you when a deadline is almost due, or when there's a new filing on your docket, or just to perform research. So our always on proactive legal assistant is always watching, learning, and executing. It's as simple as typing in your docket number or describing the case that you want to start, and your associate will get to work. It will draft filings, it will draft emails, correspondence, research, and all of that will be validated and cited with hyperlinks. We'll take a look at that and also formatted in your firm's voice. We allow firms to give us style guides and templates. Of course, all of that intellectual property belongs to the practitioner or the firm, but we use it for their own automation in their own isolated environment. And then we give it to you. The platform will deliver it to you so that you can review it, make your edits, check everything, file. Our goal really is to give you frictionless lifecycle support. If you are spending as much time reviewing an AI draft and checking the sites and trying to figure out where it got a particular quote from, whether the quote is even real or not, you might as well draft it yourself. You're gaining no time savings and you're just getting frustrated while increasing your risk surface. but with an end-to-end lifecycle suite that has that built-in hallucination detection and verification with easy one-click links so that you can immediately find and resolve what it is referencing. Now you start to see productivity gains that allow you to focus on what you really like to do as an attorney, which is developing novel legal arguments, looking at the details of a case, and performing that kind of in-depth research that allows you to win. So we are integrated with various courts, DC Superior Court, PACER, and we're moving to state level courts. And this allows us to keep everything tethered to your actual docket and documents. We also have automated updates whenever there's docket filings, and we also have automatic deadlining, which we'll take a look at. So we discussed working where you already are. You don't have to worry about prompt engineering. You don't have to worry about learning a new interface. You can collaborate over email the way that you typically do with your colleagues already. We'll take a look at the site verification shortly, but you can also upload anything that you've drafted or perhaps anything that your opponent has drafted and have it try to resolve all of the sites and return links for everything that is real. And if it can't resolve something, it will let you know, hey, I can find this. You might want to check if something about this is hallucinating. We talked about using a firm's templates or style guides so that the drafts mirror personal tone, preferences, and the way that you prefer your documents to be structured. Again, with agreements that you keep all of your own intellectual property, we don't train on it, and we don't share it with anybody else. We'll take a look at the onboarding shortly, but this is both for clients, so you can have a streamlined way that their actual factual allegations, details, and documents get to you, but also so that we can draft initial complaints and documents for you with as much accuracy and factual basis as possible. The right precedents, and we'll take a look at the statutory and case law research. Deep research to identify weaknesses, opponent playbooks, and critical factual details. Our products proactively fight your cases 24/7 and then send the findings to your inbox. So you can think of it as a second chair that never sleeps. And then we offer collaboration features for your legal team. We also have best practice security, data encryption, privacy, and we do not train on any of our user data. So some of our current practice areas that we're live in are contract disputes, intellectual property, patents, immigration litigation, credit and debt, employment cases, discrimination, RICO, real estate, tax, FOIA, insurance, Medicare, and agriculture. So let's take a look at one of our actual applications. This is JuristAI, which is currently live for all federal civil matters, and that we will be releasing, and we'll be releasing state level accessibility Q1 of next year. Currently, it is also active in DC Superior Court cases. So it's as simple as inputting a case number here for an active matter or describing what it is that we'd like, or describing what kind of case we'd like to start. So let's say we are representing Sarah Silverman in her case against OpenAI for intellectual property theft and trademark infringement. Once we sign up, we will be taken to the onboarding where we will identify whether we are representing ourselves pro se or whether we are acting as legal counsel for someone else. And let's say that we don't already have a case that has been filed in court. So let's go ahead and get started with drafting the initial complaint. We are Sarah Silverman and we are filing against OpenAI. Then we're going to upload as much contextual information as we possibly can to give the AI context about the case. Now we'll go through the complaint drafting onboarding, which involves inputting the case narrative, the factual story, our working case theory and legal roadmap, some of the key dates, the interested parties, the strengths and weak spots, our writing style guide. Then we can see that the system has recommended a class action complaint in demand for jury trial, but we could also manually override that. Let's go ahead and generate the complaint. While it's generating, it's going to use the user information, the case background, a motion template. It's going to generate top caption, research precedents, formulate legal arguments, and insert references. So while it's loading the case background, it's going to look at the docket, the documents, all previous interactions that you've had with the system, court filings. Our motion templates, we start with in-house motion templates that are designed by Mark and the rest of our legal team, just as a basis. And then we generate a top caption that is specific to your jurisdiction that you're going to be filing in. We build a detailed research brief that summarizes the issues, and then we use both semantic and lexical search, but we never use AI for this. We use actual databases, and then we insert those throughout the document. We post-process anything AI gives us to see if there are any sites that it inserted. We delete those. We get the real research, figure out where it should go, determine what research is most contextually relevant where, and then insert that. We also show you some of the precedents that have come up so you can take a look at them, click the link, and determine if those are the ones that you want in your document. And then we grant you your initial complaint. So this is the filing checklist for determining venue, the civil cover sheet, summonses, filing fee or waiver, filing a complaint, and then addressing the package to the court. But let's go through and add a existing case. So here we have our Pacer search. Let's go ahead and search for the case Klein versus Velenos Principal Capital. Here we find this RICO case in the Northern District of Texas. Let's go ahead and add it. This is the right case, and I'm going to be representing the plaintiff in this case. Our system pulls the entire docket and any documents that you can find for free But we also have the opportunity here to upload all of the case documents and associate them with the docket entries so that everything can be contextually relevant. Once we've onboarded the case, we're going to go ahead and let the platform know what our working case theory is. That's going to inform the system as to how the case is set up, how it's going to conduct research, and the structure of all of the pleadings that it's going to generate. Then we're going to let the system know what we think are the strengths and weak spots of this case. Now the system is going to work on classifying the docket entries as to who filed which docket entries. It's going to prepare a stakeholder digest that's going to summarize the key facts of the case, arguments, opponent playbook, and some other insights that we'll take a look at. It's going to prepare the initial ground research for the case, start looking at deadlines, due dates, preparing calendar invites for you. It's going to start setting up automated digests with respect to research and new filings throughout the case and building your autonomous proactive workspace. It's going to look at some of the possible next steps and it asks you what you think it should start working on next. And here it is. Our case is open. It was filed July 29th of 2025. Here's our case number, Klein versus Bonos Principal Capital Inc. So we can see here we have the core factual narrative, the current status, the fundamental facts, the case type and stage, key pending motions, what the case is going to turn on, critical deadlines, the claim snapshot, the key filing dates, the factual and legal complexities, strategic recommendations for the plaintiff, anticipated opponent playbook, risks, and blind spots. We're also working on some big data analytics for these kinds of cases, but we'll take a look at that at a future date. Here we can see these are some of the important deadlines in the case that the platform has already figured out. So it labels the deadline as to whether they are for the defendant or for the plaintiff, and it does so according to Northern District of Texas's local rules. Additionally, it will send you a calendar invite that will let you know a week beforehand that a deadline is coming up, and then a week after that a deadline has passed if the defendant or plaintiff for whom the deadline applies does not respond in a timely fashion. Let's go ahead and take a look at the document. So this is the docket. You'll notice that this is quite a bit more enriched than a PACER docket. So there's quite a few things that are going on here. Let's go ahead and take a look at the docket from this order. At the very top, we have generative predictive AI adversarial response. So this allows us, whether we are the plaintiff or the defendant, to kind of see what the opponent's next filing might look like. Before you file your case in open court, we have the petitioner preliminary filings, and these are best practice for your jurisdiction. and they allow you to essentially assemble your entire filing package. Once we do receive filings from the court, then they are categorized according to who filed and according to what stage of litigation. So we can see that as a court preliminary filing, a plaintiff pretrial filing, all the way from discovery, trial, judgment, and post-judgment. Additionally, we can summarize any one of the individual filings here, and we have some best practice motions that are associated with the first instance of anything that is filed on the document. So it is a highly enriched place to see everything that is going on with the case. And additionally, once you have uploaded anything or one of your colleagues has uploaded anything, you can download any of these entries, the original copies from our platform so that you have one place for all of the docket and document management. Let's go ahead and go to generate documents next. So here is our generate documents page. And we see here that the system has recommended a couple of next steps: a motion to compel discovery, request for production to the defendant, and notice of deposition of the defendant. And it also explains why it's recommending it based off of the context of the case. There are ongoing disputes regarding defendant's compliance with discovery, and although a motion for discovery is pending, a motion to compel and provide the court a formal vehicle in order of prompt production to the defense continue to resist or delay. We can also see our previously generated documents here. And we can look at some other options. So we are free to select our own document here if we don't want to go with one of these recommendations. And you can also manually input a different motion type if you can't find it in this dropdown for the system to generate. And of course, if you have your own templates, then we can include those so that the system respects your own motion practice based off of your expertise and your proficiency as an attorney. Let's go ahead and generate one of these documents. Let's go ahead and do this motion to compel discovery. Once you click the button to generate document, it's going to ask you, why are you filing this motion? So it wants you to define legal strategy, prioritize your key arguments, anticipate and address counter arguments, make sure you mention any court-specific preferences, and then clarify the relief sought. Here, we're just doing a brief test document to see what the system can output. Let's go ahead and generate. This is going to take a couple of minutes because there's quite a lot going on in the background. And this is one of the key things that differentiates us from ChatGPT. If you ask ChatGPT to go ahead and generate a motion, it'll spit something out pretty fast. But it's unaware of your writing style. It's unaware of the case history. The template that it's going to put out was not actually designed by an expert lawyer. The top caption may not be jurisdictionally relevant, and the research precedents will be totally unreliable. Additionally, you'll have to copy paste it and put it into a Word document. This is a 9 to 10 step process that is manually guided by expert attorney logic so that in one shot, essentially, you get something that would have taken your paralegal or your associate several hours to do. You'll get it within about 3 to 5 minutes. The way that we actually conduct the research is the system will take the motion template, only the arguments and then it will take the case context and the user input, and then it will prepare an initial draft. We then take that draft and compartmentalize it into several sections. Then we redo each one of those sections to make it more robust. Then we post-process that draft to see if AI inadvertently included any sites, and then we delete those. From there, we take that context and we use that to create both semantic and lexical searches. We take those and then we perform semantic and lexical searches for any United States constitutional articles, amendments, federal rules, United States Code, statutes, and then ultimately case law that is relevant to the argumentation that we're building. And of course, if it is state level, then we do the same for state level research and sources. And then we get those primary sources. We never let AI actually touch any of those sites. Instead, what we do is we have various models that will read those opinions, produce a summary. We will then create arguments that are relevant to the case context and that the draft specifically that we are producing. And then we have real sites with real links and then summaries of the way that we should use these opinions throughout the document. And then we figure out, okay, we have this document with all of these placeholders and we have all of this validated research. Where should it go? The system will then intelligently reinsert it throughout the document. So at the end, you get a jurisdictionally formatted document according to the motion template that you wanted with actual validated research according to the facts of the case. And we can see here that our step loading lets you see a little bit behind the veil of the Wizard of Oz here. After the placement plan is resolved, the agent rebuilds the document paragraph by paragraph and inserts hyperlinks for the match the appendix. So let's take a look at some of the citations here that the platform has given us for this document. We see that it's pulling from federal rules, it's pulling from the Constitution, it's pulling from United States Code, and it's also pulling case law here with a hyperlinked site that takes us right to the opinion. And we can see there's also a contextual analysis as to how this opinion bolsters and substantiates our arguments. Let's go ahead and take a look at one of these hyperlinks. Here it's taking us to the law library that we have, our free LitiGAI law library. But if we're dealing with a document that is not in our law library, here we can see an example of an opinion that we have here. But if it's not there, then it will take you to Cornell, or it will take you to another validated source so that you can always check and evaluate the pin site, make sure that everything is above board. Although there is extensive post-validation, we want to make it easy for you to do your manual validation. We click here, and it's going to go ahead and figure out where throughout the document these federal rule sites, these Constitution, amendment, article, and case law sites belong. So let's go ahead and take a look at the document. Let's go ahead and save it and open it up. So we can see this document. This is our first time taking a look at it. So we can see this document. This is our first time taking a look at it. It's coming right out of the platform with the case number, with the top caption, and then the argumentation that is relevant to the case and relevant to the inputs with our hyperlinked references to federal rules of civil procedure, the factual basis for the motion, the research that we've done, strewn throughout the document, where it makes the most sense, and then additional research at the end for you to utilize if you need it to further bolster your argument. So that's how motion generation works. We also offer the ability to search through your uploaded documents in the case using retrieval augmented generation. If you're looking for specific quotes or specific aspects that you can add to your exhibits or as part of the briefs that you're preparing, we offer two kinds of research. One of them is standard research, which will use semantic and lexical search to find you constitutional and federal rule and case law sites. But we also have this option here where you can upload a draft and it will actually take your draft, determine where research should be throughout the document, go and do the relevant research, and then insert it almost like an associate that is completing a draft on your behalf. So you can see here, I can go ahead, upload a document, click that, and then once it runs, it will let me know that I can get the document in the email, that I can get the document back in my email. Are some excuse. So we can see here that we are getting back United States code that we can take a look at. See that we're getting United States code back, Federal Rules of Civil Procedure, and then we are getting case law with analysis if we put in a more robust search. We also have the feature here that allows us to take any document that we've written or perhaps that our opposing counsel for the opposing party in the case has written and analyze it for hallucinations. We are currently checking whether case sites are real or not, whether they are miscited, and whether they are relevant to the argument at hand. And we're currently working on checking quotes as well. So this is really valuable for anyone to check their own drafts, but also for you to check the drafts of opposing counsel to see if there are any hallucinations in the arguments that they've made before you spend perhaps a couple of hours trying to find case law that doesn't even exist. And this also acts as another layer of insurance after you've done your own due diligence so that you can be sure and be confident that everything you are submitting to court is valid or legitimate, especially when we work with paralegals or associates that perhaps have been using AI since they were in college and now they're in the workforce and maybe are not as trepidatious with respect to some of the dangers that these hallucinations can present. Now you have a quick way to check anything that a colleague gives you or any research that you've done and just flag the most potential concerning pieces of that. So we can see here that it's done an analysis of everything that was in this document, and it's also given us links. Rule 37 of the Federal Rule of Civil Procedure, 90% relevant, and analysis as to why it's relevant, all the way down for every single one of the sites. If there are any sites that it's not sure about, it would flag them. In this case, there were no potential issues, and then it also analyzes the usage of our citations and quotes throughout the document. You can also store all of your original case files here behind one pane of glass and then be able to retrieve them, and your colleagues can collaborate and keep all the documents in one place. Additionally, we have chat so that you can speak to the case context, you can analyze, you can develop a profile surrounding the case, prepare your trial interrogatories, build tables, so on and so forth. So that is the entire platform from the front end. But what I'd like to show you next is actually in my email inbox. So this is my email. And you can see I've got quite a lot of emails back and forth from agent@juristai.org. And essentially what agent is a way for you to do everything that I just showed you on that platform over email. So I can send agent email, hey, can you research this issue for this case? And it will go ahead, do the research, send it back to me email, and also attach it as a document. I can say, hey, what do you think we might want to do next in a particular case? And I'll say, hey, I recommend that you take a look at one of these. I can ask it to draft an email for me for a particular client or stakeholder. I can ask it to check a document and give me back the critique and analyze whether the citations are real or whether there are any that I need to take a look at because they may not be real. I can upload documents and tell it that, hey, I need you to upload this to the case. Whenever there's a new filing, it will analyze the docket, pull the document if it can, update your stakeholder digest, and then try to determine what your next step might be and produce a preemptive draft of that as well. It'll also ask you, hey, I've been looking at this case. I think we might want to do one of these things next. Am I on the right track? What do you think I should be doing right now? It will also conduct deep research on your cases and look at the controversial issues and come back with an analysis. So it is proactive. It will let you know when a deadline is coming up, let you know when a deadline has passed. It will do research. It will draft documents. It will draft what it thinks your opponent might do next and say that and send that to you. And it will also ask you questions about your case. It will let you know when deadlines are overdue, and it will also put deadlines on your calendar for you by sending you a calendar invite and let you know a week beforehand and a week after. So we can see here, this is an invite for one of these cases. And here is a deadline that is overdue. So agent is designed to really be an autonomous, proactive colleague that you can collaborate with over email if you'd rather do that instead of using the front end user interface. And anytime anything is going on any one of your cases, it's going to proactively take a look at the docket, take a look at the documents, try to figure out what it should be doing next, draft it, send it to you, update any deadlines that may need to be updated, and generally behave as close to a human associate as possible. We really appreciate your attendance here at the CLE. We hope that it was really beneficial and that you learned a lot. We really enjoy presenting to you. We'd love for you to set up a time to speak with us. You can sign up to do that on www.juristai.org, or you can reach out to me directly, Ali@juristai.org, or to mark.underwood@juristai.org. Thank you so much for your time. We really appreciate having you, and we look forward to collaborating with you guys soon.